Assalamualaikum and a very good morning to all students. So for today's class, the slides I already shared them inside your WhatsApp group, and I already uploaded them on your UNIEC virtual website, so you can download the slides there. So today we will be learning about contract law. So contract law, there are three parts of the of contract law. So for this class, we will cover two topics, which is law of contract one and law of contract two. Another part of law of contract, we will cover it during our class, during our next class, which will be in 2 weeks' time, because next week we have Chinese New Year public holiday. So our next class will be on the following week. Okay, so you can hear my voice, right?
Yes, madam.
Oh,
Yes, ma'am.
good. Okay. Okay, so when we talk about law of contract, there are actually a number of things related to law of contract. So one of them, which we will learn during this slide. So for law of contract one, what we will cover is we will talk about the elements in order to have a valid contract. So if you want to create a contract with someone, if you want to create a valid agreement with someone, what are the elements that you need to fulfill? So there are 6 elements that you need to fulfill, which is offer, acceptance. Why is it not showing? Wait. I do this. Okay, so in order to have a valid contract, so if you want to create an agreement with someone, if you want to create a contract with someone else, and you want that contract to be enforceable, well, what we means when I say the word enforceable means that if you want to be able to get some damages, if you want to get some ganti rugi, if something happened to the contract, you need to make sure that the contract fulfills all the elements for a valid contract. So if your contract fulfills all these 1, 2, 3, 4, 5, 6 elements, then you will have a valid contract. If you have a valid contract, then you can take action using that contract in the court. So if your contract is not a valid contract, that contract is not enforceable in court. So if something happens, if you want to go to the court to get your rights, you will not be able to get it because your contract is not a valid contract. Okay, so that is the important thing about make sure that your contract fulfills all the elements. Okay, so so for this topic, for this topic 4, we will learn about the functions of law of contract. Why do we have a law of contract? And then we will also learn about the 6 basic elements of a valid contract. So what are the 6 elements that you have to make sure um, is inside your contract in order to have a valid contract? Okay, so when we talk about contract, contract is not only about something which is in written. So a contract is basically an agreement between two or more parties which is enforceable by law. So as long as you have an agreement, the agreement must have at least two parties, but it also can have more than two parties. But the contract, if it is enforceable by law, if you can bring the contract to the court in order to get your remedies, in order to get your damages, that contract is a valid contract. So when we talk about contract, actually many of us enter into contracts daily without realizing that we have done so. So contract is not only something that you sign. I mean that if you want to have a contract, you must have a proper A4 paper which is signed by both the vendor and the purchaser, and it must be signed properly. So that is one form of contract, but actually there are many other things that you have done daily which is also a contract. For example, now maybe you don't do this, but when you are when you are having class face to face, who is there anybody here who take public transport to go to class during the face-to-face class?
Yes, ma'am.
So you take what kind of transportation to go to class?
Train.
LRT.
LRT.
Yeah, LRT.
LRT. So LRT, whenever you go to the LRT station, and then when you go to LRT station, what do?
Buy token,
You buy token, then
and then we have to scan, and then we have to go inside. We cannot bring food, drinks we cannot bring. And of course, we have to, if there's any elderly people, pregnant or someone, we can give space, something like that. They have some rules there, actually.
okay. So when you go to the LRT station and you buy the token, so that is when you create a contract with the LRT operator. So when you go to the counter and you want to buy the ticket, so that offer. You offer to use their service. So in exchange, you will pay the money. So that is offer. So that is a contract. So whenever you go to a LRT station and you buy ticket, or if you have something like LRT touch and go card, whenever you touch the card when using the steel, that is when you create a contract with the LRT operator. So that is also a form of contract. Even though you didn't sign anything, even though you didn't say anything, you just buy ticket and then you go inside the LRT. That is still a contract between the passenger and the LRT operator. So a person create a contract with another person whenever they take a bus, whenever you park your car in a car park. So when you go to the shopping mall, what will you do when you go to the shopping mall? You will go through this gate and then you have to take out the ticket. So that is when you create contract there. When you want to watch a movie in the cinema during non-COVID time, you go to the cinema and then you go and buy the ticket. So that is also a form of contract. You also create a contract with the cinema operator. So you pay money to the cinema operator and in exchange, they allow you to watch their movie. So that is also a form of contract. Similarly, if at the restaurant, the chef make your order and then they serve the food, that is and the chef and the restaurant. So when you go buy groceries, that is also we create contract every day. We create contract every day, and many times in a day. Sometimes, whenever you have an agreement with anyone else, or maybe it can just be by conduct, but it is still a contract. Okay, so a contract is same as an agreement of an element of agreement. So you must agree to do something or not to do something not to result in a contract recognizable by the law. So it means that all is a contract. contract. Okay, so that is a contract. So the functions of law of contracts, there are three functions of law of contract. Provide stability and predictability for both buyers and sellers in the marketplace. So when you have a law of contract, they provide some kind of stability. They provide stability. So you know that when you want to go to the supermarket, whenever you take something at the, from the aisles, and then you go to the cashier, pay for your food, you will get the food. So you can just take it, put it inside your cart, but you have to go through the cashier, and then you have to pay for all the things that you have taken from the aisle. Then you will have the item. So the supermarket will also be assured that all the items that they put on their shelves will be paid for by the customer before it is taken home by them. So it provides stability. It provides predictability. Everyone knows everyone knows their job. The buyer knows that if they take the items home, they have to pay for it. The supermarket knows that if the customer wants to take any item from the aisle, they have to pay for it before they can take it home. So everyone is happy. The customer get their item and the supermarket get their money. So it is a win-win situation. So that is one of the functions of law of contract. It provides stability and predictability for both buyers and sellers in the marketplace. So the second function of law of contract is it assures compliance with a promise. So this is more like when we are talking about a formal contract, a written contract between two parties. So when you have a contract between two parties, you can ensure compliance with the promise. So you can be sure that when someone has signed a contract with you, that person will comply with whatever they agreed to do inside the contract. So for example, if this is a contract of a contract to supply some people, if you have a contract to supply things, so you can make sure. So inside the contract, you will put that, okay, so the agreement is between A and B. So A agrees to buy some items. For example, A agrees to buy 20 boxes of oranges from B. So they sign a contract that A will buy orange from B, and then A will buy orange from B, and B will supply the orange to A. So A agrees to pay money for the orange. So when you have a valid contract, you can make sure that whatever happens, A must pay the money to B, and B must supply the orange to A. So if anything happens, for example, A received the orange from B, but A refused to pay for the orange, or A had paid for the orange to B, but B does provide oranges which are already rotten, buah orange yang dah rosak. So what will happen? So for the first situation, they pay but B doesn't supply the orange, A can take legal action. A can bring B to court in order to get their orange. Or for example, when B already supplied the orange but A doesn't pay. So what can B do? B can bring the contract to the court. B can get their money from A by taking the contract to the court. So it ensures compliance with the promise. So when someone had agreed to do something, when you have a valid contract, that person will have to comply with the contract. If they don't comply with the contract, if they don't do whatever they have to do inside the contract, you can take action against them. So that brings us to the third function. So the second function is you can ensure that whenever someone has promised to do something, they will do it. So that so the law of contract will ensure compliance. And at the same time, if the other party doesn't do, if any of the party doesn't do what they have to do under the law, so it will entitle the non-breaching party to relief when a contract is breached. So for example, like the situation I said before about A and B, if A doesn't pay for the orange, or if B doesn't supply the orange, or if B supply the oranges but they supply rotten oranges, A can take action. A, which is the victim in this situation, they can take action in the court to get relief. So relief is the same as damages and remedies. So when we talk about ganti rugi, relief, damages, and what is one more? Relief, damages, and compensation. Damages, compensation, remedies. All these four things, relief, damages, compensation, remedies, all this, it means the same thing. It means ganti rugi. Okay, so that are the three functions of law of contract. So why do you have a law of contract? It's because of these three functions. Okay, so any questions about the functions of law of contract?
So far none, madam. Okay.
Okay. Okay, so look at the elements of a contract. So if you want to create a contract, you must make sure that your contract fulfills all these elements. There are 6 elements for a valid contract. So the first element, if there must be an offer. So if you want to have a contract, first there must be someone who offer to do something. Okay, so there must be one party who offer to do something or offer not to do something, and there must also be another party who accept the offer. So there must be someone who offer to do something, and there must be someone else who accept the offer to do something. So first you must have an element. And the second, you must also have an element of acceptance. And then you must have also the element of intention to create legal relation. So this of intention to create legal intention. Actually, if you have signed a written contract, usually this third element is easily fulfilled. But sometimes intention to create legal relation is an element which sometimes cause problem when you have an agreement which is not written, or if you have an agreement between family members. So if the contract is, if the agreement is between family members, sometimes they have intention to create legal relation, and sometimes they don't have the intention to create legal relation. So if you have the intention to create legal relation, it's easier because if you have the intention to create legal intention, you can, if the other person breached the contract, they don't want to fulfill their responsibilities under the contract, you can take action in the court. But if there is no intention to create intention to create legal, what was I thinking? Not legal intention to create legal relations. Okay, so but if there is no intention to create legal relation, we call it a social contract. A social contract cannot be enforceable in court. So for example, when your mother promise you that if you clean your room, your mother will pay you 20 ringgit, for example. Your room is so messy, your room is so dirty, your mom have to bribe you. Your mom have say that if you clean your room, I will give you 20 ringgit. Okay, so you relying on that promise, you clean your room. So your room becomes sparkling clean. But after you have cleaned your room and you ask your mom, Mom, I already cleaned my room, pay me your 20 ringgit. Your mom have the option not to pay. If she can prove that there is no intention to create legal relation. Okay, so because it is an agreement between you and your mom, so the agreement is what we call a social contract. So if it is a social contract, it is not enforceable in court. So if your mom doesn't want to pay you 20 ringgit, you cannot take any legal action against your mom. Okay, so that is the third element. So the fourth element is consideration. So consideration is what we call value for a promise. So it means that if someone offer to do something and someone accept that offer, there must be consideration. Both parties must get something from the contract. So that is what we call consideration. The consideration does not need to be in the form of money, but there must be some kind of consideration between the parties. Both parties, if A and B create a contract between them, both parties must get something out of the contract. Okay, so that is consideration. And then the fifth element is certainty. Certainty is when you want to enter into a contract with someone else, the subject matter must be clear. The subject matter must be certain. You cannot say that I want to sell the house to you at the price of 700,000 or 800,000. You cannot say something like that. You have to be clear. You want to sell the house at what price? You want to accept. You want to accept the offer to. You want to buy the house at what price? So there must be a certainty, an element of certainty. And then the sixth element is capacity to contract. So the capacity to contract is this one is quite easy. If you want to enter into contract, you must have the capacity to contract, which means that you must have the ability to understand the contract. You must have the ability to understand what is the contract and what is the effect of the contract. So on the sixth element, we will see who are the kind of people that does not have the capacity to contract. So if you are a child, a minor under the age of 18 years old, you don't have the capacity to contract. Or if you are a person of unsound mind, so you have some kind of mental illness, maybe due to your you are at OKU, or maybe if it is due to your age. So if you are a person who is unsound, you also does not have the capacity to contract, because it is presumed that you don't have the ability to understand what the contract is all about. Okay, so we'll see each element one by one. So if the balance 4 elements are not quite lengthy, but the first element and the second element is quite lengthy. So if you at any part you don't understand what is offer, what is acceptance, please ask. You can ask either during the chat using your voice, or you can ask on the meeting chat. Okay, so we'll see the elements one by one. So the first element of contract, the most important element of a contract is, if you want to have a contract, you must have an offer. So offer is when one person signifies to another his willingness to do something, or he signifies his willingness to abstain from doing anything. He is said to have made an offer or proposal. So basically, when you talk about offer, we are talking about someone offer someone else something. So when you offer something to someone else, it can be said that you are making an offer. Okay, so offer is something which is capable of being converted into an agreement by its acceptance. So when we talk about offer, it means that you have to offer to do something to someone else, to do something for someone else, then it will be an offer. If you are creating a contract to do something for yourself, it is not an offer, because offer must have at least 2 parties. Okay, so an offer is something which is capable of being converted into an agreement by its acceptance. So it must be made between at least 2 parties. An offer can be made orally or in writing. So under the Malaysian law, in Malaysia, the main act that govern contracts is the Contracts Act 1950. Already uploaded the Contracts Act both inside your WhatsApp group. I also already uploaded the Contracts Act inside the UNIEC virtual. So the main act that covers contract in Malaysia is the Contracts Act 1950. So if you open the Contracts Act 1950 at Section 2. So this term, the first one, when one person signifies to another his willingness to do or to abstain from doing anything, that is the definition of offer according to the Contracts Act 1950. So throughout this topic 4, topic 5 and topic 6, we will rely on the Contracts Act 1950 a lot. So it will be good if you can download it. So whenever I refer to certain section, you can refer it to. You can refer the sections to, and then because inside the Contracts Act, they also have these illustrations. So illustrations is like examples to explain what the section is all about. So it will be good if you can download the Contracts Act 1950 also for our class today and the next class for topic 4, 5 and 6. Okay. So an offer can be made orally or in writing. So under our Contract Act, it doesn't specify that a contract must be made in writing. So you can make an offer orally. So a contract can be fully unwritten. So it can be an oral contract. But the only problem with oral contract is it is difficult to prove, because an oral contract is not written, so it is not in writing. So it will be a little bit difficult to prove to the court. So that's why it will be prudent, it will be good, it will be a better idea if you want to have any contract is to put it on writing. This does not only refers to the complicated contracts. Even if you want to lend some money to your friends, you baik sangat, you kaya, you want to lend some money to your friends, you want to let your friends borrow your money, it is still better if you create a contract for that lending of money. Because if something happen, your friends refuse to pay or anything, you can take that contract and get your money back from the court. So you can take your friend to the court if your friend refuse to pay your money. So that is why I said that a contract is better to be in writing. It can be an oral contract, but an oral contract will be harder to prove. So it will be better if a contract is made in writing. Okay, so an offer must be a definite promise to be bound, provided certain specified terms are accepted. So when you make an offer, you must be ready to fulfill your obligation inside the offer. Oh, so if you want to offer, for example, you want to offer to sell a house to someone else. For example, you have a house. You have a house and you want to sell the house to someone else. So you must make sure that if the other party agrees to buy your house, you have to sell the house. Okay, so you must have a definite promise. So if you want to someone to do something, you must make house. So if they are ready to accept your offer, you must have a house to sell to them. So it must be a definite promise. Okay, so if you want to sell a house, if you want to make an offer, it must be a definite promise. So you must have something to offer. So if you want to do something for someone else, make sure you are available to do it for that person. Okay, so the communication of an offer is complete when it comes to the knowledge of the person to whom it is made. Why some people say they cannot why some people say they cannot access to Microsoft Teams? How many people are inside? Wow. Okay, 41. Sorry. Okay, so the last one, the communication of an offer is complete when it comes to the knowledge of the person to whom it is made. So if you want to make an offer, it can be in many forms. You can call someone to make an offer. You can write an email to tell someone that you are offering them something, or you can even write a WhatsApp chat to someone else to tell them that you want to offer something. So the communication of the offer is complete when it comes to the knowledge of the person to whom it is made. So if you made an offer to someone through a call, so when you call someone and you tell someone, hey, I want to sell you something, that is when the communication of the offer is complete. So that is when you had made an offer to the other person. Similarly, if you make an offer through an email, once the email is received by the other party, you have complete your communication of your offer. And for instantaneous type of communication, it's easy. Like for example, whenever you send a WhatsApp chat to someone else to offer them something, once they receive the WhatsApp chat, the offer is complete. So if it is for instantaneous communication, for example, WhatsApp, email, or call, when you can directly, you can get instant reply, the communication of offer is easy. So it is complete when that person receive the call, that person receive the email, that person receive the WhatsApp chat, the communication of the offer is complete. But the communication of an offer is a bit tricky when it comes to an offer made through, we'll look at it later. But if an offer is made through post, through surat, through a letter, if it is posted, so when you send the offer letter, the offer is only complete when it comes to the knowledge of the offeree. So it means that if you send a letter to offer to send some, if you send a letter to offer something to someone else, the offer is only complete once they receive the letter. Okay, so the communication of an offer is only complete, the communication of an offer is only complete when the other person receive the letter. So that is what it means by the communication of an offer is complete when it comes to the knowledge of the person to whom it is made. Okay. Okay. So if an offer is made in words, so if the offer is an oral offer, so you call someone and say, hey, I want to sell you something. Hey, I want to offer you a job. So that is an offer made in words. Or for example, when you send an email to someone else, or if you send a letter to someone else, it is an offer made in words. So it is what we call an express offer. But if the offer is not made in words, it is made by conduct. So it is an implied offer. So for example, like I said earlier during our class, when you go to the LRT station and you touch your Touch 'n Go card on the steel, and then the door open, that is when you make an offer. But the offer is an implied offer because the offer is not made by words. You did not say anything to the steel. You just touch your card and the gate open. So it is an offer made by conduct. So it is called an implied offer. Similarly, in an auction, I'm not sure if you have been to an auction, but during an auction, if someone advertised to sell something during an auction, you offer to buy that thing not by saying anything, but by putting your card up. So if you put your card up, your card number up, so it means that it is an implied offer because you did not say anything. So it is by conduct. So whenever an offer is made by conduct, when you make an offer by not saying anything, it is what we call an implied offer. Okay, so an offer may be made to a particular person. So you can make an offer from A to B on. So only two parties. An offer can be made to a particular person. An offer can also be made to a particular group of person. So sometimes maybe you want to make an offer not only to one person, but you want to make an offer to a number of person. So that is also an offer. And an offer can also be public at large. You can make what we call a unilateral offer. So that is an offer made to the public at large. That kind of offer is also valid. Okay, so there is this term which we call invitation to trade. So there is in certain situation, even though it seems like it is an offer, it is not an offer. It is actually an invitation to trade. It's not an offer. So an invitation to trade is an offer to consider offers. So for example, when you have a brochure, for example, you you create a catalog for IKEA. For example, when you are working, if you are a worker in IKEA, you have this IKEA catalog which you send out to your customers every month using email. So that catalog is not an offer. That catalog is on invitation to trade. So invitation to trade is an offer to consider offers. So it is a request for expressions of interest. So it is the same when usually when we talk about invitation to trade, it means something like advertisements, brochures, or iklan jawatan kosong, job vacancy advertisement. That all of that is what we call an invitation to trade. So it is a request for expressions of interest. So you advertise that thing in order to attract people who are interested to buy your things, or you want to attract the interested people who wants to apply for the job. So you have your job vacancy advertisement. So a job vacancy advertisement, it is what we call an invitation to trade. Why you have a job vacancy advertisement is because you want people to apply for the job. So it is what we call an invitation to trade. So why it is so important to differentiate between what is an offer, what is an invitation to trade? Why? Is because if it is an invitation to trade, it is not an offer. So whenever, when it is only an invitation to trade, if someone express their interest, for example, like I said, you create a job vacancy advertisement. If it is only an invitation to trade, you put up the job vacancy offer on your on JobStreet, for example. Whenever anyone responds to that advertisement, that person is making an offer. So when that person makes an offer, you have the choice either to accept their offer or not. So you have the choice either to call them for interview or not. So that is an invitation to trade. So if it is only an invitation to trade, whenever someone responds to the job vacancy advertisement, you have a choice whether to call that person for interview or not. But if if something is not an invitation to trade, if it is an offer, the other person does not have to re-offer something. They only have to accept the offer. If they accept the offer, it is already a binding contract. So okay, so we can differentiate. If you put a job vacancy advertisement, it is only an invitation to trade. But on the other hand, if you have already called someone for interview and you are interested to take that candidate as your employee, you send a letter to offer position. So that is when it is an offer. So when you offer someone for a position, so for example, that person has already passed the interview and you are interested to take them as your employee, you send them a letter of offer. So once you send them a letter of offer, then they have the choice either to accept your offer of employment or not. So that is the difference between invitation to trade and an offer. So if you just put a job vacancy advertisement, it is not an offer. The other people who are applying for the job, they are making an offer. And then you have the choice either to call them for interview or not. But after the interview, if you are interested to take one candidate as your employee, you send an email to them telling that we are interested to offer you the position of blah, blah, blah inside our company. That is when you make an offer. And when you make an offer to that particular employee, when that person accept your offer of employment, it becomes a binding contract. So that is the difference between an invitation to trade and an offer. Okay, so there are many instances which are generally regarded as an invitation to trade. So some of them include auctions. Auctions is in Malay what we call lelong. And then advertisement of tenders. For example, if you have a company and you want to renovate your company, you advertise, you want to get some tenders, people who are interested to renovate your company. That is also an invitation to trade. So whenever you put out the advertisement of tenders, if for example 5 companies are interested to do renovation works for your company, that company and the 5 company will give an offer to you, and then you will choose from these 5 companies which company you want to use to do this. So that is also an invitation to trade. Catalog is also an invitation to trade. when you have a catalog, for example, if you put a catalog on your website, IKEA website, it doesn't mean that all the items inside the IKEA catalog is available. Sometimes there may be 100 items in the catalog, but maybe only 90 of them are available. The other 10 are not available. If it is an offer and some accept to buy the item, if you did not provide the item, it will be a breach of contract. But if the catalog is only an invitation to trade, there is offering to buy the item, and you can choose whether to accept the offer or not. If the item is not available, you can say no, we don't have the item, so you cannot sell it to you. So that is the difference between ITT and contract. And offer. And one more thing, goods displayed in shop windows and shelves. So whenever you go to the supermarket, whenever you go to Aeon, whenever you go to Tesco, whatever items displayed on the shelves, whatever item displayed on the aisles, all of them are invitation to trade. When you take the item and you bring it to the cashier, that is when you make an offer to buy the item. And then the cashier, if when they scan the barcode of the item and then they receive your money, that is when they accept your offer to buy the item. So that is when you have a valid contract between you and the supermarket. Okay, so this is the case of one case on items displayed on shelves of a pharmacy. So in this case of Pharmaceutical Society of Great Britain and Boots. In this case, this is a pharmacy which have a self-service system. So inside this pharmacy, they have a self-service system. So the pharmacy, they will put all their medicine, they will put all their items on the shelves, and the customer will take the item from the shelf and they will bring them to the cashier. So there is a pharmacist on duty at the cashier's desk. So under the law in this country, there is a law which states that you cannot sell medicine without the presence of a pharmacist. So under the law, if you want to sell any medicine, you have to have a pharmacist there. So a pharmacist must be present before a medicine can be sold. Okay, so the problem here is, the issue is whether Boots have committed an offence under a law that prohibits the sale of medicine without the presence of a pharmacist. So in this case, the plaintiff, they said that when they take the item from the shelf, they are making an offer. They say that when items are put on the shelves, the pharmacy is making an offer. So when they take the item from the shelf, they are accepting the offer. So that is the contention. So what they claim? They claim like that. But the court held that display of goods on the shelf is an invitation to trade, not an offer. So if the items are on the shelf, it's still not an offer. When you take it, put it in your cart, and you go to the cashier, that is when you make an offer. So as a buyer, your buyer make an offer to buy the things. And then the cashier, when they receive the money, they scan the product and they receive the money, that is when they accept their offer. So putting a display of goods on the shelf is still an invitation to trade, not an offer. Okay, so offer only happens when a customer brings a medicine to the cashier and makes an offer to buy the item. So like what I said lah, the sale only take place at the cashier's counter when the cashier accepts the customer's offer to buy the item. So this is about invitation to trade. So when offer happens, when acceptance happens. Okay, so there are also other cases, like the case of Konto versus the Public Service Commission. Job, as I stated before, it is an invitation to trade. It is an invitation for any qualified person to apply. So When the person who are interested in the job apply for the job, the person who are applying for the job are making an offer. So when you are called for interview, then the company is considering your offer to accept you as a worker. Okay, so in the case of MN Guna Majumder against RE Dono, if you are still in the midst of discussion, if you are still in the midst of negotiation between two parties, it does not create an offer yet. So discussion does not bound parties. After discussion, if you are not interested to buy the item, you can left the place, because a discussion does not bound parties. So when you are still negotiating, when you are still discussing, there is no offer or acceptance made. Okay, but if it is clear in the circumstances that the party intends their words or conduct to constitute an offer, the courts will be prepared to construe it as such. So it just means that if in the situation it seems that one of the party are making an offer, then the court will call it an offer. But it depends on the facts of the case. The general rule is, if you are still negotiating, if you are still discussing, there is no offer, there is no acceptance. Okay, but there is this one case, a quite unique case and very famous, the case of Carlyle against Carbolic Smokeball Company Limited. And this case, the company, they advertise. So this is just like what happens nowadays when people create testimonial. People create testimonial on the social media, or they create advertisement on the on TV or on social media, stating that if you use our product, you will be slim. If you use our medicine, you will be healed from diabetes. You will be healed from hypertension. So similarly, in this case, Carlyle versus Carbolic Smokeball. This company, Carbolic Smokeball, during that time, there was a case of influenza. If I'm not mistaken, this is during years of 1918 until 1920. There is a case of Russian flu, influenza, which has killed around, I'm not mistaken, around millions of people. Millions of people had died due to this influenza. So this company is taking advantage of that pandemic, and they said that if you use our smoke ball, they have this, I'm not sure how does it look like, but they offer that we have this kind of smoke ball that if you use our smoke ball, you will be healed. You will be healed from influenza, and you will be healed from many kinds of illness. So the company is alleging that. The company is stating that if you use our smoke ball, you will be healed from your illness. So the company goes one step further and stating that if after you use our smoke ball for, I'm not sure what is the period. There is a fixed period lah. So macam for example, they said that if you use our smoke ball for 3 months and you are still not healed from influenza, we will pay you 100 pounds sterling. So the company is putting it in the advertisement, said that if you are not healed from influenza, we will give you 100 pounds sterling reward. It is equivalent for nowadays if someone put on advertisement that we can assure you that if you use our product, you will be slim in 2 months. If you are not slim in 2 months, we will pay your money back. So it is something similar like that. This is something like that. So that is what the Carlyle, in this case of Carlyle versus Carbolic Smokeball, that is what they state. They state that if anyone use their product but still got influenza, they will give them reward of 100 pounds sterling. Okay, so they state that they will offer 100 pounds sterling to anyone who still succumb to influenza after using their smoke ball for a fixed period. So this one customer, the plaintiff, she used the smoke ball for the period of time as required, but still they contracted influenza. Okay, so they contracted influenza, and when they contracted influenza, they claim for the money. So the plaintiff, which is one of the customer, they claim for the money of for the reward of 100 pounds sterling. So in this case, the court held that what Carlisle versus Carbolic Smoke Ball did, what the company did is they are not making an invitation to trade. They are actually making an offer. So in this case, the offer is what we call the third category, this one. An offer made to the public at large. So what the company is doing is actually they are making an offer to the public at large. So they are making an offer. Okay, so I offer that if you use our product for 3 months, you are still not here, we will pay you money. So that is not an invitation to trade by that, but it is an offer. So when they make an offer like this, when the customer use it and she still does not heal from the illness, she can claim because she already accepted the offer by buying the product. So they can claim and they will get their money. So nowadays, if someone create advertisement like this, something like, if you use our product for 3 months and you are still not healed from diabetes, we will pay back your money. You can claim your money using this case. Because in this situation, it is not an invitation to trade, but it is a contract. It is an offer. Okay? So that is all for offer. Do you have any question on offer?
No, madam. I think I'm okay.
Anyone else? Do you have any question on offer?
No, ma'am.
No question. Okay. So if there is no question about offer, we will continue to the second element. The second element is acceptance. So the first element is if you want to create a contract, there must be someone must offer to do something. Someone must offer something to the other party. So when the person to whom the proposal is made signifies his assent thereto. So when someone offer to do something for you, or if someone offer something to you and you accept the offer, it can be said that you have accepted the offer. So there is the second element, which is acceptance. Okay, so acceptance can be by words, or it can also be by conduct. So for example, in the case of the LRT station, when you put your card on the steel, that is when you make an offer, and when the gate open, that is when they accept the offer. They accept your offer to use their public transport. Okay, so that is that is what we call an implied acceptance. Okay, so wait. So if it is made by words, if you for example, when someone call you to offer you something and you say okay lah, I'm interested to buy it, or okay lah, I'm interested in the job. So that is when you have accept the offer. Similarly, if someone send an email offering you a job and you write a written email saying that thank you for your offer, I am interested in taking the position as blah 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 blah, that is when it is said to have you have accepted the offer. So when it is made by words, through writing or through oral, it is an express acceptance. If it is made through conduct, for example, at the supermarket, someone when the cashier scan your product and receive money from you, that is when they have accepted your offer to buy the product by implied acceptance. Okay, so an acceptance must be absolute and unqualified. You cannot put a condition to your acceptance. You cannot put I agree, but I agree provided. You cannot say something like that. If you say I agree provided, I agree, but it is the acceptance is not unqualified, so it is not a valid acceptance. Okay, so if parties are still negotiating, if you are still negotiating the terms of the contract, you are still negotiating how much is the product, you are still negotiating how to send the product, how to receive the product, who will receive it, that is still not an agreement. So if you are still in the midst of negotiating, there is still no contract between you. Or if, for example, someone email you saying that I am offering you a job as a officer at my office, and I will pay you 1,500 ringgit per month. And then you send to accept your offer, but I want to negotiate on the salary, some kind of conditions. So that is not acceptance. That is what we call a counter offer. RM1,500, and you say that I want the job, but I want a higher salary. I want a salary of 2,000 ringgit. That is when you make a counter offer. So you are countering the offer made by the employer. So at that time, the employer have the choice. The employer have the choice to say, yes, we agree to pay you 2,000 ringgit, or sorry, but we are not able to pay you 2,000 ringgit. So we will offer the job to someone else. Even if the company said that, sorry, we cannot pay you 2,000 ringgit, we will offer the job from the company. Because when you have a counter offer, so the company have the choice either to receive your counter offer or to reject your counter offer. Okay, so that is a counter offer. And then a conditional assent is also not acceptance. If you put a condition inside your agreement, it is still not as sign which state but the document contains a clause. The clause state that it is subject to a formal contract to be drawn up. For example, maybe you just discussing to sell how to send, but you still state in the document it is subject to a formal contract to be drawn up. It means that the document cannot be enforceable until a contract is signed. The contract until you have signed a formal contract. Okay, so so that is what we say. Kata dah jap. Ni I'll try to move to a better place. Is it still lagging here? Is it still lagging?
Not really, ma'am. It is okay, right?
Yeah, because I'm not sure. My internet on my laptop sometimes it lags. Okay, so if I am lagging a lot, or maybe if my voice disappeared, if my voice suddenly disappeared, just tell me. Maybe I have to move closer to the modem. Okay, so a conditional assent is not acceptance. It means that if the document state that this is not a valid contract, we still have to sign a formal contract for this to be applicable. Then it is still not a contract. So you still have to sign a formal contract before the agreement can come into existence. Okay, so an acceptance must also be made within a reasonable time. It means that if someone offer you something and they give a time due date, for example, I want to a house for a price of 800,000 ringgit. Can you come back to me in 1 week time? For example, if someone send a WhatsApp chat to you stating that I want to sell you a house for 800,000 ringgit, but can you come back? Can you tell me whether you are interested or not in 1 week time? So after 1 week, if you still have not accepted the offer has already lapsed because an acceptance must be made within a reasonable time. So if there is a time prescribed, the acceptance must be made before the time lapse. But if there is no time prescribed, if in the offer the person who offered to sell you the house doesn't say anything about when must you receive, the acceptance must be made within a reasonable time. For example, when someone offered to sell you a house, I am offering to sell you a house at 800,000 ringgit. And then 2 months later or 3 months later, you suddenly interested to buy that house, and then you message them again. You reply to the message, yes, I am interested to buy the house at 800,000 ringgit. At that time, if the seller states something like that, oh, sorry, I have already sold the house to someone else, you cannot take any action against the seller because it is not that your acceptance is not made within a reasonable time. So if you take too long to accept, and at that time the seller already sell it to someone else, the other party already make a contract with someone else, you cannot sue the other party because the acceptance must be made within a reasonable time. Okay, so an acceptance must also be expressed in a usual and a reasonable manner. So an acceptance must be communicated. It cannot you cannot say something like silence is not a manner of acceptance. And then acceptance.
Excuse me, madam.
Yes.
Shouldn't there be a third person party to ensure proof of the acceptance to make sure that it's valid?
Third party, what do you mean by third party?
Macam saksi macam tu to make sure that the acceptance has been made on behalf of the person giving the offer and also the individual accepting the offer.
Usually a witness is not used to usually lah kalau in formal contract, a witness is not needed to prove that someone has accepted the contract. Usually in formal agreement, a witness is you have a witness because you want to make sure that it is the correct party who are entering into the contract. That's why if you want to have an agreement, for example, to sell a house or to for example, a sale and purchase agreement, will be signed by the seller and the buyer, and it must be witnessed by the lawyer. The witness is not to make sure there is an offer acceptance, but the purpose of a witness is usually to make sure that it is the correct party who are entering into the contract. So in later, if something happened, the person want to take the action against the court, the other party cannot claim that I did not sign the contract. That is the purpose of witness. Because usually acceptance must be communicated. So for example, when someone send you an email offering you something, and when you reply to the email accepting accepting the offer, that is a complete acceptance. It does not need to have any witness. It's only if in the situation of oral acceptance, maybe you need a witness because you want to prove to the court that you have accepted, but you have nothing to show to the court. Then you need a witness. If you have something in writing, you don't need a witness to show that you have accepted the offer. Does that answer your question?
Yes, madam, it does. Thank you very much.
Okay, so an acceptance must be expressed in usual and reasonable manner. So you cannot say something like, I a house, if I don't receive if I don't hear anything from you in 1 week, I will presume that you want to buy. So that kind of thing, you cannot do that because silence is not a manner of acceptance. That is exactly what happened in the case of Feldhaus versus Bentley. If I'm not mistaken, this person is selling a horse to the other person. And he stated that if I don't hear from you in 1 week time, I assume that you want to buy the house. Yeah, you want to buy the horse. So in a situation of a contract, silence is not a manner of acceptance. So the other party must say it expressly or impliedly that yes, I want to accept your offer. And acceptance must also be communicated or brought to the notice of the offeror. So if you want to accept something, you must communicate it. If someone call you wanting to offer something to you, if you want to accept, you have to say, yes, I want to accept. If someone send an email, you have to reply the email. If someone send a letter, you have to reply the letter. Or if someone send a letter with a reply form stating that if you are interested to join, if you are interested to join, you can fill the form and send the form to me. So if you if you fill in the form and you sign the form to the other party, it can be said that you have accepted. So what's important is that acceptance must be communicated. So it must be brought to the notice of the offeror. Okay, so in this case of Hyde and Ranch, the defendant is offering to sell a farm to the plaintiff. So the plaintiff reply, I want to buy the farm, but I want to buy it at 950 pounds sterling. So the defendant disagree. So after that, the plaintiff said, tak apalah, it's okay lah. So I want to buy the farm at 1,000 pound. But at that time, the defendant said, no, now I don't want to sell you the farm anymore. So in this case, the court held that once the plaintiff put a counter offer, the defendant have the choice either to accept the offer, to accept the counter offer, or to reject the counter offer. So in this case, the defendant does not want to sell it anymore. So so it means that he has rejected the counter offer. Okay, because the offer is to sell for 1,000 pounds sterling. So when you make a counter offer, I want to buy it, but I want to buy it cheaper. If the other party say that no, I don't want to sell it to you anymore, you cannot see anything. Because the counter offer, when someone make a counter offer, then it is your choice either to accept the counter offer or to reject the counter offer. Okay, so when you want to communicate your offer, when you want to communicate your acceptance, if it is through instantaneous communication, for example, once upon a time we have Telegram, you have Telex, we have phone, we have email. Nowadays we have WhatsApp, we have Telegram, we have Signal, we have Facebook Messenger, whatever. If it is an instantaneous communication, something that when you send, the other person will immediately see it, the offer or acceptance must to be valid. So both parties, I must see it I must receive the offer for me to accept the offer. So whenever I receive the offer, you send the offer and I receive the message, that is when I already received the offer. When I send you reply saying that I want to buy that thing, that is when I had accepted the offer. So that is easy. Instantaneous communication is easy. It is quite complicated when it comes to postal rule. When someone send an offer to you, not by email, but through letter, through snail mail. What we call letter is what we call snail mail. When someone send you an offer using a letter, which is what we call a non-instantaneous communication, it will follow what we call a postal rule. So what is a postal rule? A postal rule is when you send an offer to someone using a letter, the offer is only complete, the communication of the offer is only complete when the offeree receive the letter. So when you send an offer through a letter, the offer is only binding against you. If you cannot take back your offer once the other person has already received the letter. Okay, so when the other person decides to accept the offer, when he send the acceptance letter, at this time the offeree already bound by the acceptance. But I want to buy the product. I want to accept your offer. once they put the letter inside the post box, the accept is already by the letter. I know this is a bit complicated, but that's why I said when it comes to postal roll, it is a bit pening sikit. So just for easy understanding. So just for easy understanding, if you some obviously is I don't want it. So because the offer is still not complete before the other person receive the offer. Wait, actually tidur lagi. Lagi. Is here okay or is it all still lagging? I'm literally moving next to the modem now. I think my internet is macam nak sambung? Try. Masak. Muat tak? Okay, so yeah, if it's still lagging, you can you inform me. Okay, so when we talk about postal rolls, so it means that once you send the offer letter, it is only your offer is only complete when the other person receive the letter. So on the other hand, if the other person wants to accept the offer, once they send the letter to you, you are already bound by the acceptance. even though you have not received the letter yet. But once you receive the letter, the person who send the acceptance is bound by the acceptance. So it means that if you want to cancel your offer, if you want to withdraw your offer, or in law we call it if you want to revoke your offer, you have to inform them before they receive the offer. So for example, if you want to sell a house and you don't want to sell the house anymore, you are withdrawing your offer, you have to call that person and say that I already sent you a letter to sell your house, but actually I don't want to sell the house anymore. So that is when you can revoke your offer. At the same time, if the person who already accept your offer send the letter to you, at that time he is still not bound by the acceptance, but you are already bound by the acceptance. But so at the time, during the course of transmission, when the letter is still not received by you yet, the other party can call up and say, I already sent you a letter saying that I want to buy a house from you, but actually I don't want to buy the house anymore, so I want to withdraw my offer. So that is when you can revoke your acceptance. Okay, so this is the concept of revocation. So you can revoke an offer, so you can cancel your offer. It must be communicated by notice of revocation by the offeror. So it can be by email, it can be by call, it can be by WhatsApp message. But it can only be revoked at any time before its acceptance is complete against the offeror. So in the in situation of letter, you can only revoke your offer before the other person send a letter to accept your offer. Before the letter is sent, before they put the letter inside the post box, you can still revoke your offer. But once they already put the acceptance in the post box, you can no longer revoke your offer. Similarly, an acceptance must also be communicated. So if you want to revoke your acceptance, you must call the other person. You can call them or WhatsApp them or whatever. And it can be revoked at any time before or at the moment when the letter communicating his acceptance reached the offeror. So similarly, if you have already accepted the offer and you want to revoke your acceptance, you don't want to buy the house anymore, you can revoke provided that the letter have not received the proposal yet. So before the letter is received by the other party, you can call them up and say that I don't want to buy the house anymore. So that is how you can revoke your acceptance. Okay, so once you have revoked your offer, there is no offer anymore. And once you have revoked your acceptance, there is no acceptance anymore. So there is no contract between you two. Okay, so that is how you can revoke your offer and how you can revoke your acceptance. So that is the second element. So there are also other ways to terminate an offer. One is by lapse of time, like what I stated before. If you already state in your offer saying that if you want to buy the house, you have to buy it in 1 week time. So after 1 week, if you still did not receive any response from the other party, you can say that the offer has been terminated because there is a prescribed time period and the prescribed time period has expired. Or if you don't put any prescribed time period, if the other party took too long a time to receive your offer, you had already sent an offer and only after 3 months he wants to reply to the offer, you can also say that at that time the offer has already lapsed. Or the second situation, if the acceptor failed to fulfill condition precedent to the acceptance. For example, you make an offer, but you state that I want to offer a position of an officer to you, but with the condition that you have to have a driving license. You must have a driving license because I want you to be a driver for the company. So if you fail to fulfill the condition precedent, if you don't have a driving license, that is when an offer can be terminated because you, as an acceptor, you fail to fulfill the condition precedent to the acceptance. And then the other way is by death or mental disorder of the proposer. If the person who made the offer died, or the person who made the offer become mentally unsound, have some kind of mental illness, and the death or the mental illness of the proposer is known to the acceptor, that is when an offer is terminated. For example, someone offered to sell you a house you have not received the offer yet, but the seller die. So once the seller die, the offer is terminated. Okay, so that is the first element and the second element, which is offer and acceptance. Any question on offer and acceptance?
Madam,
Yes.
can offers be renegotiated even after any issues were to happen?
Renegotiated when? After it is signed or before it is signed?
Before and after. But yeah, I'm not sure about that one. It's a little bit confusing.
If you are still negotiating a contract, for example, you have a contract with the other party, and you are still in the midst of negotiation, you are still negotiating the terms of the contract, there is still no contract yet until you have finalized all your negotiations and you both have signed the contract. That is when there is a valid contract. At the same time, if you want to change some terms of the contract, for example, you already have a contract, a valid contract between you and the other party, and suddenly after maybe 2 years, you realize that there is some problems with the original contract. What you can do is you can renegotiate the contract, and when you renegotiate the contract, you have to sign a new contract. So the new contract can either be a complement to the original contract. So you just put, you just have one contract and then you have another contract to complement the first contract, or you can create a new contract altogether, and the new contract can just, what we call it, supersede. I'm not sure what is it in standard English. The new contract can cause the old contract to be invalidated. So you can sign a new contract, and then once you sign a new contract, the old contract is not in force anymore. So it's like that. So first, if you want to, So if you want to sign a contract, you have to negotiate all terms first. But after you have signed the contract, there is something wrong, you want to change the contract, you have to sign another contract. So that's how it works. Does that answer your question?
Yes, it does, madam. Thank you very much.
Okay. So any other question on offer and acceptance? Okay, so if there is no question, we will go to the second element, which is intention to create legal relations. Wait, Okay, so the third element of a valid contract is that you must have an intention to create legal relations. So intention to create legal relations is basically when both parties to the contract intend to be legally bound by the agreement. So when both parties agree that whatever inside the agreement is bound to them, so if anything happen, you can bring the contract to the court. So if one party fails to fulfill his contractual obligation, the other party can enforce the contract in court. So that's why you need to have intention to create legal relations. Okay, so if you want to see whether the parties have the intention to create legal relations or not, usually they will see that when a reasonable person look at the parties' word and conduct, would that person say that there is an intention to create legal relations? So that's what I said before. We have two types of agreement, which is commercial agreement and social agreement. So social agreement is agreement entered between spouses, siblings, relatives, or friends. For the example I have given before, your mother said that if you clean your room, she will pay you 20 ringgit. So if your mother and you have not signed any contract, it will only become a social agreement. So when it is a social agreement, it is not legally binding. It is not binding on the parties unless there is an evidence to show the contrary. So that is what a social agreement is. For example, in this case of Balfour versus Balfour, Mr. Balfour worked in the colonial service in Ceylon. So Mr. and Mrs. Balfour, they returned to England when he was on leave. So when after they returned to England, due to medical reason, because Mrs. Balfour falls sick, so she was unable to return to Ceylon with Mr. Balfour. So Mr. Balfour said that it's okay, honey, you stay at England and I will pay you allowance of 30 pounds sterling every month. But once he went back to Ceylon, he failed to pay the allowance. So the wife claimed for the allowance. So in this case, the court held that the agreement was unenforceable because there is no written contract between them, and it is only a social agreement because Mr. and Mrs. Balfour never intended the promise to have a legal force. So in this situation, it is only a social agreement. It is not enforceable in court. On the other hand, in the case of married versus married, in this case, husband and wife separated. So upon separation, the husband agreed to transfer the wife, transfer the house to the wife, provided she pay the mortgage installment on the house. So the husband said that, okay, so if you pay the installment for this house every month, I will transfer the house to your name. So they have the agreement, and the agreement was put in writing and signed by both parties. So after that, the wife paid for the installment. But even after she had paid all the installments, the husband still refused to transfer the house to her. So in this situation, the wife sued for the house, sue for the promise at the court, and the court held that in this case, the agreement was binding on the husband. Why? Because even though it is between ex-husband and ex-wife, the parties' conduct, which is by putting the contract in writing, which is the act of formalizing the agreement, showed that there is an intention to create legal relation. So that's why I said if you want to have an agreement, especially with people you have a close relationship with, you want to have a contract with your friends, or if you want to have a contract with your parents or your siblings, it is good, it is better for you to put it in writing, because when you put it in writing, you can argue that there is evidence to show that this is not that there is an intention to create a legal relation between you two. So it become a contract that is enforceable under the law. So on the other hand, if it is a commercial agreement between two strangers, or agreement between two companies, it is a commercial agreement. So if it is a commercial agreement, it is presumed that the parties have the intention to create a legal relation. So whenever two strangers or two companies sign a contract, we can say that the contract is a commercial agreement. So if it is a commercial agreement, usually they have the intention to create legal relation. If you want to say that it is only a social agreement, you have to prove. So that is the second element. The second element is quite simple. Any question on the intention to create legal relation?
No, madam.
Okay. So if there is no question, we continue to the fourth element, which is consideration. So consideration is what we call value for a promise. So when you want to sell someone something and the other person agree to buy something from you, there must be a consideration. You must get something from the contract. The other person must also get something from the contract, because an agreement made without consideration is void. So if you have an agreement and that agreement does not brings any benefit to any of the party, it is a void agreement. So a void agreement is an agreement which is not enforceable in law. So you cannot get any remedies under the contract. Okay, so under the law, an agreement made without consideration is void, but there are certain exceptions. So there are 4 exceptions under the law. So the first exceptions is if it is an agreement made on account of natural love and affection between the parties standing in a near relation to each other, the contract does not need a consideration. So for the first exception, the example is when a father wants to um, give a house to his daughter. For example, a father wants to give a house to his daughter. The father can transfer a house to his daughter even though the daughter does not pay a single cent, because it falls under the first exception. It is an agreement made on account of natural love and affection. Or in Malay we call it balasan kasih sayang. So, but for the first exception, it only works between spouses, husband and wife, and between parents and child. Other relationship cannot use. If you have any other type of relationship between the parties, you cannot use the first exception. If I'm not mistaken, between grandfather and grandchildren also, you cannot use the exception. The exceptions is only for husband and wife or parents and child. Okay, so that is the first exception. The second exception is promise to compensate a person for something that he has already voluntarily done in the past. So this is the easy example is, for example, someone is drowning. For example, you are drowning at the sea and then someone help you. So the person, one person, a good person nearby goes into the sea and that person save you. So because you are feeling gratitude to that person, you said that I will give you 50,000 ringgit for saving my life. Okay, so after you have promised that person that you will give that person 50,000 ringgit for saving his life, if you did not pay the 50,000 ringgit to the person, that person can sue you because it falls under the second exception. Promise to compensate a person for something that he has already voluntarily done in the past. So that person has voluntarily saved you, but you already promised to compensate that person. So when you have already promised to compensate a person, you have to fulfill your promise. So you have to pay that person for what you have already promised him. So that is the second exception. So the third exception is promise to compensate an act that the person promisor is legally compelled to do. For example, if a policeman save you, if a policeman help you settle a case, for example, he is doing his job because he is legally compelled to help a citizen who have any problems with the criminal law. But after that, if you have promised to pay him for what he had done and you did not pay that, the other person can take action against you because it falls under the third exceptions. Or the fourth exceptions is promise to pay a debt barred by limitation law. So under the limitation law, um, for example, under the law of contract, after someone has breached a contract, you have 6 years to claim. So under the law, once someone has breached a contract, you can claim, but you have to claim within 6 years. If after 6 years you still have not claimed for the breach of contract, you cannot claim anything because it is already barred by limitation law. But for example, just before it is barred by limitation law, or for example, after 7 years, suddenly the person who owe you money come to you and say that put in writing that I will pay the money that I owe you 7 years ago. So at that time, you can still claim for the money even though the debt is actually barred by limitation law because that person made a promise in writing to pay that debt. Okay, but if there is no written promise by the person who owe you money, after 6 years you can no longer get any claim under the law because it is barred by the limitation law. Okay, so that is consideration. So past consideration is good consideration even though the act has been done, even though someone has already saved you. After that, then you promise to give him money. That is still a good consideration. And it can also move from third party. Even though the agreement is between A and B, it doesn't matter if the consideration comes from C. So the consideration does not have to come from the offeree or the offeror. For example, in this case of Venkata Chinaya versus Verikata Maya, in this case, a mother transfer her property, certain lands to her daughter. So the mother give her daughter some lands on the condition that the daughter have to pay, this is an India case, 653 rupees every year to his, I think his auntie, I think, because the lady sister. So the mother said that I will give you my property, but with the condition that every year you have to pay 653 rupees to my sister, to the lady sister. So once the daughter get the property, the daughter fail to pay the amount promised. So the daughter does not transfer 653 rupees to the plaintiff every year. So the plaintiff, which is her mother's sister, sue the plaintiff. Okay, so in this case, the court held that even though the consideration does not come from the plaintiff, I mean the consideration does not come from the auntie, but the consideration comes from the comes from her mother, it is still a good consideration. So a consideration can move from a third party. The consideration for the agreement between defendant and plaintiff has been furnished on behalf of the plaintiff. So even though the money is not the money comes from a third party, is still a good consideration. The easy example for this consideration can move from a third party is in a situation, for example, your father bought you a car. So your father bought you a car, and then the contract is between you and the seller and the car seller. So the contract is between the child and the car seller, and then but the consideration does not move from the child because the child doesn't have any money. The money is paid by the father. So in that situation, even though the money is not paid by the child, the money is paid from by her father, it is still a good consideration because a consideration can move from a third party. It doesn't matter who pay, as long as there is a consideration. Okay, so as long as both parties get something from the contract, it doesn't matter who pay for the consideration. So that is the second one. And then the third one, a consideration need not be adequate. It means that a consideration must be sufficient but need not be adequate. As long as it has a value, it is irrelevant. It is irrelevant how much is it. For example, if you want to sell a house, the house is value at $1 million, but you don't want to sell the house at $1 million because you like the person who is buying the house. You want to sell the house cheaper at $500,000. It doesn't matter because it is your right. It is right of the contracted parties. They have the right to sell to have the consideration at any value. Okay, so if you want to sell 100,000 house for $1,000, it is still very enforceable. It doesn't matter if the consideration is not adequate. Even if it is too cheap, if it is too expensive, it doesn't matter because the consideration does not need to be adequate. And then the next one, part payment may also discharge an obligation. For example, if you borrow 500,000 from another person and the other person said that you can discharge your obligation by paying only 200,000 to me. So once you pay the 200,000 to the other person, the obligation can be discharged even though it is not the full amount. So like this in the example of the contract itself, A owes B 5,000, A pays to B, and B accepts that 2,000 is the payment for the whole debt. So once once A pay 2,000 ringgit, the contract is discharged. It doesn't matter if he hasn't paid in full, as long as both parties agreed that this payment can discharge our obligation. Okay, so that is consideration. Any question on consideration? No question? Okay, so if there is no question, we will look at the fifth element. The fifth element is certainty. So the terms of an agreement cannot be vague. It must be certain, because if the agreement is uncertain, if the subject matter is uncertain, it is a void agreement. So the contract is not enforceable under the law. For example, if you want to sell someone toys, you must specify what type of toys they are. Or if you want to sell a house to someone, you must specify the house is how much. How much is the price of the house? How to sell the house? Where is the house? For example, you have 5 houses, and then you tell your friend, I want to sell you a house. You have to specify which of the 5 houses that you want to sell. Because if you do not specify which of the 5 houses that you want to sell, it will create uncertainty in the agreement. So if it is not specified, the elements of certainty is not fulfilled and the contract is void. So there is no contract between you two. Okay. So now, for example, in this case of Karupanceti and Swatian, in this case, the requirement of certainty was not met when the parties agreed upon the granting of a lease at 35 ringgit per month for as long as he likes. As long as he likes is not a certain term. So you have to put a term on it. Okay, so that is the fifth element of certainty. Must be certain. And then the last element is capacity. So the last element, which is the sixth element, if you want to enter into a contract with someone else, you must have the capacity to contract. So capacity to contract means that you have the ability to understand what are the terms of the contract. So what the contract is all about. You need to understand what is the contract, what are you signing, and what is the effect of the contract. If you can understand what is the contract, or the nature of the contract and the effect of the contract, it is stated that you have the capacity to contract. And you must also understand that if you fail to fulfill your obligation under the contract, it can result in legal liability. Okay, so in Malaysia, two types of person is considered does not having the capacity to contract. The first one is if he is under the age of majority, he is a minor, he is an infant, someone who is under the age of 18 years old, does not have the capacity to contract. And the other person is a person who is unsound of mind, orang yang have problem with his mental abilities. That person does not have any capacity to contract. So if you are a child, can you sign a contract? Can, but only certain types of contract. Normal type of contract cannot be signed by a child. So if you are a child, if you are a minor under the age of 18 years old, if you want to sign a transfer of land, you want to sell a land to someone else, you cannot do it. Or you want to buy a land from someone else, you cannot do it because a contract entered into by a minor is void. Exceptions is if the contract is for necessaries. So if the contract is for something that you need to use at that time, so you need that things, you need that service to live, to improve your conditions of life. For example, you contract to have food, to have clothing, to have basic medical treatment. All that kind of contract is an exception. So a minor can sign a contract for necessaries. And a minor also can sign a contract for education and training. For example, a child can sign a scholarship agreement because it is also considered necessaries. And a child can also sign a contract for insurance because insurance is also considered a necessaries. Okay, but when we talk about necessaries, it means food. Food is what you have to eat to be able to stay alive. But it doesn't mean that you have to buy expensive food. It just means that you have to you can sign a contract to buy food. Luxurious articles are not necessary. So food is necessary, but if you want to say that buying a caviar or maybe some expensive food is necessary, it is not necessary. Food is necessary, expensive food not necessary. So luxurious article is not necessary. And for example, in the case of Scarborough against Terzaka, in this case, the minor every day he rode a bike to work every day because it is a distance of 15 kilometer. So he buy a new bike and sell his old bike. But he does not want to pay for the balance the balance price for the new bike, because he said that a new bike is not necessary. But in this case, because the minor use the bike every day, he need the bike, so the bike is considered a necessary. So the contract is valid, even though it is entered into by a minor. So it depends on the situation of life of the child. For example, if a child already have so many clothes, if the child already have a number of clothes, the child cannot say that buying a clothes is necessary. But if the child does not have any clothes, or if his clothes are all does not fit anymore, then it can be said that the child buying a clothes is a necessary. So it depends on the nature of the goods and what the child actually needs. Okay, and then one more for contract of insurance is it can be signed by a minor. So a minor who has attained the age of 10 at least can sign a life policy. But if the child is below 16 years old, he can only do so with the written consent of his parents or guardian. So a child can sign a contract for insurance, but he need a permission from his guardian. So that are the unsound mind is easy. Someone who is incapable of understanding the agreement, and they cannot judge what are the effects of the agreement, what is the effect of the agreement. So if you are a mental patient, you are suffering from any kind of mental illness, or if you are a drunk, so you does not have the capacity to enter into a contract, so you cannot sign a contract. Okay, so that is the 6 elements of contract. Do you have any question on the elements of contract? Yes. Sharin Rose, finally you can join the class. Any question on any of the elements of contract?
No, madam, was quite clear.
Okay. So if there is no question, I will give you around 10 minutes break. And then after that, we will continue with our other topic 5, law of contract 2. So if you have any question for law of contract 1, the elements of contract, if you still have any question, you can reserve your question and we will discuss it during our evening class. Okay, so I'll give you 10 minutes break. Okay, good morning, dear students. So, in topic 4, we have already learned about the elements of a valid contract. So, if you want to create a contract, what are the elements that need to be fulfilled in order to have a valid contract? So, for this second part, what we will look at is we will look at the concept of privity of contract. This is a simple concept, which means that only parties to a contract can sue or be sued under the contract. So it's just a concept of saying if you want to have any rights under the contract, you have to be a party to the contract. So that is the concept of privity of contract. And then we will also discuss on the contents of a contract. So inside a contract, especially a formal contract, there will be many terms. There will be many clauses inside the contract. So we will see that each clauses, what does it mean? Is it a conditions of a contract? Is it a warranty of a contract? Is it an exemption clause? Is it an express term? Is it an implied term? So we'll see all that under the second part, which is contents of a contract. And then we will also look at the third part, which is factors vitiating a contract. So under the law, there is this one condition that if you want to enter into a contract, you must enter into a contract with free consent. So you must consent, you must agree to enter into a contract. So we will see under the third part, what are the factors which vitiated a contract. So we will see that, wait, mana tadi? We will see that there are 5 situations where a contract is not given under free consent, and what will happen to the contract that is not given under free consent. So I hope we will be able to finish all 3 parts this morning. But if we are not able to finish all the 3 parts in the morning, we will continue during our tutorial, and I will inform your tutor. For those who are inside Miss Fatin's group, I will inform your tutor to finish whichever part we have not able to finish by this morning. Okay. So first, we will look at the privity of contract. So privity of contract is a simple concept which stated that a contract only occurs between parties to the contract. So if you want to have a if you want to take any action under any contract, first you must make sure that you are parties to the contract. You must be one of the people who enter into the contract, because a contract cannot confer rights or impose obligations on third party. So if you want to get anything from a contract, or if you want to sue for anything under a contract, you need to be a party to a contract, because contract cannot confer rights or impose obligations on third party. So whatever you want to do, you must do it between the two of you. And then a third party cannot also cannot sue on a contract. So for example, if the contract is between your wife and another person, you as a third party, you cannot sue on a contract because you are not parties to the contract. So if the contract is between your wife and another person, if there is anyone who can sue under the contract, it is your wife. If your wife refuses to sue under the contract, you cannot do it on her behalf. Okay. So that is the general rule. Okay, so that is the general rule. So there are some exceptions to the rule. I mean, there are certain situations where a contract can confer rights onto third party, or a contract can put obligation on third party, but the exceptions are the law of agency, the law of assignments, and trust or promises. So, and just a simple example. One example is if if something happened to a child, or for example, if a child want to sue under a contract, the child cannot sue by himself because he is minor. So if a child wants to sue under contract, the child, in order to sue under the contract, the child must sue, his guardian must sue on behalf of him. So that is some of the exceptions. So macam kalau in a normal situation, third party cannot sue on a contract, but if the contract involves a child and the child want to sue for something, the only person who can take action on behalf of the child is his guardian. So it will be under the law, or it will be under the concept of agency. Yeah, so another person act on behalf of the child. Or for example, in situations of someone put something on trust. For example, someone, a father died, and when he died, he said that all my properties belongs to my children, but because my children are still underage, I put my ex-wife as a trustee to administer all the property belonging to the children until the children reach the age of 18. For example, in this kind of situation, if the father put some kind of property under trust, so the person who is the trustee, he is actually a third party, but he can be sued or sue under the contract because he is acting on behalf of the children. So in this situation, only if people are acting on behalf of someone else and it is allowed under the law, then you can not use this concept of privity of contract. But in normal situation, the concept of privity of contract states that only parties to the contract can take action. Only a certain situation, usually it is a situation when you, someone else is acting on behalf of you, then you cannot use the concept of privity of contract. So basically, that is the concept of privity of contract. It's not very important actually, but we'll continue with the more important part of the topic, which is contents of a contract. So in a contract, there are many terms. There are many clauses in a contract. So some of the terms is what we call conditions. Some of the terms are what we call warranties. And we also have express terms. But there are also some terms which are implied into a contract. So the terms is actually not in the contract, but the term can be implied into a contract. So when you sign a contract, it is presumed that you also agree to these implied terms. And there are also some clause in the contract which we call an exemption clause. So we will see what are conditions, what are warranties, what are express terms, what are implied terms, and what are exemption clause, and what are the effects of these terms in the contract. Okay, so first we look at the conditions and warranties. So what are the difference between a condition and a warranty? So if a stipulation, if a clause in the contract is essential to the main purpose of the contract, if the clause of the contract is something important to the contract, something which is the main reason why the contract exists, if the condition is not performed, if the condition is not performed, or if the other party breach the condition in a contract, it may amount to the substantial failure to honor the contract. So in this situation, we have two different effects. If the clause in the contract is a condition, so if a clause in the contract is a condition, if it is breached, so someone failed to do the obligation under a contract, which is a condition punya clause. So it can be a ground for setting the contract aside. Or it can also be a ground to sue for damages. So if it is a condition, you can You can discharge yourself from the contract. So you can you can treat the contract as it has come to an end, and you can just what we call discharge the contract. So you can just end the contract if it is a condition. But if the clause in the contract is only a warranty, it is not a condition. A warranty, you cannot treat the contract as ending if someone only breached a warranty clause in a contract. You can only claim for damages. Okay, so the difference, because it is said that if you breach a condition of a contract, a condition term of a contract, it is a failure to honor the contract. So it means that it goes to the root of the contract. The contract is not, in simple words, we can say that if someone breach a condition of a contract, the contract will become useless. Because this is the main purpose of the contract, but it is breach. So the contract becomes useless. So if a contract becomes useless, the other party who is the victim of the breach can end the contract, can set aside the contract, or that person can also sue for damages. But if the contract, the terms of the contract, the clause is only a warranty. So a warranty is a stipulation collateral to the main purpose of the contract. So it is part of the contract, but it is not as important as the conditions. So it is a lesser importance to the main purpose of the contract. So if it is breached, the injured party cannot set aside the contract. The injured party, the victim, cannot treat the contract as has ended, but he can only sue for damages for any loss suffered. But still, they must perform their part of the contract. So I think this may be a quite confusing, but we will see this case. We will compare between these two cases to see which one is, why is it a condition and why is it a warranty. So whether a term is a condition or a warranty, it depends on the intention of the parties. So the court will see the intention of the parties and determine whether this term is actually a condition or if this term is a warranty. So we will see these two cases. Both case involves performer, but in the first case, the case of Posar against Pius and Pond, in this case, the court held that it is a breach of condition. So in the case of Posar against Pius and Pond, the court states that the contract can be discharged and the party can treat the contract as it already ended. But in the case of Bettini and Guy, in this case, the court states that it is not a breach of condition. Yang ada beli hari tu ada. Whipping ada. Milo tak ada. Cooking cream, whipping cream itu ada lagi ada. Okay, so in comparison, in the case of Bettini and Guy, in that case, the court states that what happened in that case is only a breach of warranty, not a breach of condition. So in the case of Bettini and Guy, the victim cannot treat the contract as ended. The victim cannot say that the contract has been discharged, but they can only sue for damages. So we will see what happens in both cases. Okay, so first, the case of Posar. What happened in the case of Posar? So in the case of Posar, the claimant, she was an opera singer. Okay, she was an opera singer, and she was contracted by the defendant to perform for a duration of 3 months. So the defendant in this case, the defendant is Pond. In this case, the defendant is Pond, and Pond has engaged Posar to become a performer for their company for 3 months, for a duration of 3 months. So inside their contract, there are certain conditions. So this, some of the conditions are how much her salary is, when will the performance start, and what will happen if they want to re-engage her as a opera singer, blah blah blah. So there are many terms and conditions inside the contract signed between POSAR and PON. Okay, so the performance start at on a certain date, 28th of November. So the company PON said to POSAR that okay, our first performance will start on 28th November, because initially in their contract it states that the performance will start on 14th. But after that, there is a delay in the start date of the performance. So the company already informed POSAR that the performance will start on 28th. So the POSAR said, okay, so I have no objection, so I will start my performance on the 28th. However, just before the opera starts, POSAR fell ill. So she becomes sick. She became ill. So when she became ill, she is unable to perform for the first 3 days of the performance. So the company is quite diligent. So they already have a backup singer. So they already have a backup singer who will perform in the event POSAR is unable to perform for the opera. So when POSAR fell ill just before the start of the opera, for the first 3 days of the performance, the defendant hired another singer. So they used their backup singer to perform for the performance during the first 3 days of the performance. So they used their backup singer. So once after the 3 days has ended, so once POSAR is healthy again, she came to the company and she said, okay, now I am already healthy. Can I continue to sing at opera? But at that time, I don't know what happened. Maybe because the backup singer is good enough. So when POSAR wants to take up her position in the performance, it was refused by the defendant. So the company said, we had already decided that we no longer need your service because we will continue to use our backup singer. Because our backup singer is well received by the audience. So we want to continue to use her. So we don't need you anymore. Okay, so when this happened, POSAR is very angry. So what happened is POSAR take action against the company for wrongful dismissal. So she stated that we already have a contract between us, and the company has breached their contract because they dismissed me wrongly. So at the trial, the court state that because POSAR failed to turn up for the 3 days of the performance, so it amounts to a breach of condition of the contract. So they state that as a performer, the requirement stating that you have to perform every day for 3 months is a condition of the contract. Because if you cannot perform if you cannot perform at the opera, the company will suffer loss because they need to find someone else to replace you. So in this case, the court held that failure to turn up is a breach of condition. So he said, so the court claimed that not being able to perform on the day of performance is a breach of condition because it went to the very root of the contract. So because the singer POSAR failed to because POSAR has already breached the condition of the contract, the company is free to cancel the contract. The company is free to rescind the contract. The company is free to treat the contract as has been discharged by breach. So in this case, what we can say that if it is a very important clause in the contract, for example, an opera singer, the most important purpose of the contract is they want to engage her as a performer in the opera. But if you fail to come to your performance, it is considered a breach of condition. So when it is a breach of condition, the other party can cancel the contract. They can rescind the contract. They can set aside the contract. So that is what is decided in the case of POSAR. In comparison, in the case of Bettini and Guy, in this case is it is on about opera also. So in this case, the claimant Alessandro Bettini entered into an agreement with the defendant. So some of the terms of the agreement stated that Bettini must perform within 50 miles of London. So the agreement states that for 1 year, Bettini must perform around London only. So she cannot go farther from London for 1 year. And then the terms of the contract only also state that for 4 months, Bettini must perform for the defendant. So Bettini must perform for Guy. So Guy will pay Bettini around £150 per month. And then the agreement also stated that Bettini must be in London 6 days before rehearsals without fail. So the agreement clearly state that for example, if you have a rehearsal in London, you have to be there 6 days before the rehearsal starts. So in this case, Bettini arrived late. So Bettini arrived only 2 days before his performance period was to begin. So needless to say, Bettini breached his condition. Bettini breached one of the terms of the contract, which states that he must be in London 6 days before rehearsal. So she was late and she arrived only 2 days before performance began. Okay, so when she arrived late, 2 days before the performance began, the defendant does not want to allow him to perform at the opera. So the defendant Guy, he was very upset, so he declined to have him perform at the opera. So in this case, the issue is whether the requirement to be in London without fail 6 days before the start of rehearsals, is it a condition or is it a breach? Is it a warranty? So in this case, the court held that the requirement to be in London 6 days before rehearsal is only a warranty, not a condition. So it states that the fact that you have to be in London 6 days before rehearsals is part of the contract, but it is not the most important part of the contract, because whatever you said, Bettini is already there before the performance start. So the main purpose of them hiring the plaintiff is because they want him to perform. So he does arrive before the performance starts, but he fails to arrive before the rehearsal starts. So in this case, the court states that it is not a breach of a condition, but it is only a breach of a warranty. So in the case of Bettini and Guy, Guy can only claim for damages, but Guy cannot terminate the contract. Okay, so can you see the difference between the facts in the case of Possart and the facts in the case of Bettini? What are the difference between these two cases? What made these two cases different?
Madam,
Mm-hmm.
may I say that the factor of why they were late, perhaps?
Mm-hmm. What are the difference?
So, that was a hard one. Yeah, I think I can't, madam. Sorry.
Anyone can point out what are the difference between the case of Possart and in the case of Bettini? What is the difference in circumstances between these two cases? The main difference in circumstances between these two cases. Does anyone? Does anyone know what is the difference between Possart and Bettini? No one can
Miss,
yeah.
maybe Possart, she didn't come to the on the performance day, and Bettini didn't
Yes.
attend the trial before rehearsal before the performance.
Yes. So that is the main difference between these two cases. So yeah. So you are correct. So based on these two cases, we can say that if you fail to come for the performance, it is considered a breach of condition because you are hired to perform and you didn't come for performance. So it is a breach of condition. But if you hired to perform you still perform, but you came late, so you are not able to rehearse with the other people, it is still a breach, but it is not a condition because you are still there to perform. So it is only a breach of warranty. So for a breach of warranty, you can only claim for damages. You cannot discharge the contract. You can rescind the contract. But if it is a breach of condition, you can rescind the contract. You can end the contract. Okay, so that is the main difference between these two cases. So you can, from these two cases, you can see that in certain circumstances, court will say that the terms is a condition. But in certain circumstances, the court will say that the terms is not a condition, but it is only a warranty. So warranty is lesser important terms, but condition is the more important terms. Okay, so do you have any questions regarding what is regarding conditions and warranties before we move on to the next type of terms? Any question? No. Okay, so if there is no question, we move on to the second type of terms. So the first type of terms is the difference between what are conditions, what are warranties. So conditions can go to the root of the contract, and you can end the contract. You can treat the contract as have ended. But if it is a breach of warranties, you can only claim for damages. You cannot end the contract. So next we will see the difference between an express term and an implied term. Okay, so in a contract, we have express terms. So what are express terms? Simple. Express terms are terms which has been specifically agreed upon by parties. So whatever written in the contract, it is what we call express term. Whatever agreed between the parties, either orally or by writing, it is what we call an express term. So what is an implied term? So implied terms are terms which are not in the contract, but terms that the parties or the courts may read into the contract. So there are certain circumstances where even if the clause are not in the contract, it is still considered part of the contract. So there are three ways to imply terms into contract. First one, by customs. So if there is a customs, that is there is a standard industry practice on something. So even though it is not written explicitly in the contract, you can put it as an implied term. You can imply them into a contract. Second one, statutory. If there is any statutory regulation that need to be fulfilled, if there is any law that you have to follow, if there is any law related to the contract that you have to follow, the law can become an implied terms, even if it is not stated in the contract. And the third one, the court can also imply terms into a contract based on the intention of parties who have signed the contract. Okay, so terms implied by custom. So in certain transactions, in certain dealings, if a custom exists, custom is adat or standard industrial practice, a trade usage exists, this can be implied into the contract between the parties. So the custom must be something very well known. It must be something certain, and it must be something which is reasonable. And it must also be consistent with the express terms of the contract. So if you want to imply a custom into a contract, you must make sure that the customs is something very popular. Everyone in the industry will know that that is a custom in the industry. So if it is something very popular, something reasonable, and something well known by everybody, something notorious, well known by everybody, the court can imply the terms into the contract, even though nothing is stated about the term in the contract. Okay, so that is the first one, terms implied by customs. The second, some terms can be implied by statutory provisions. So a number of statutes, certain statutes that imply terms into a contract. For example, if you are selling or buying things, you are subjected to the Sale of Goods Act 1957. Or if you want to buy a car, your act of buying the car is the Act 1967. So whatever stated in your contract, you still have to follow what is stated inside the Hire Purchase Act. Or for example, you want to transfer property. You want to sell your house. You want to buy a house. You have to follow all the stated inside the National Land Code. For example, National Land Code 1965 stated that if you want to sign a contract for a house, for a property which is under reserve land, you need to fulfill certain condition. Or if you want to buy a property which is under a leasehold, there are certain conditions you have to follow. So even though all these things are not stated inside the contract, you are still subjected to the statutory provision because the statutory provision is implied into the contract. So if you want to enter into any contract, so it is important for you to know that this contract, whether it is subjected to any statutory provision. So if it is subjected to any type of law, any type of act, you have to make sure that your contract must also follow everything stated in that act. Because even if it's not stated in your contract, it can be implied by the court. So you still have to follow it. And then okay, and then the third one is there are certain terms that can be implied by the court. So in some cases, the intention of parties are clear. What the parties want in the contract is clear, but sometimes their contract is not as clear. So the parties knows what they want inside the contract, but what they put in their contract does not give effect to what the parties intend. So the contract may be vague, or the contract may not have certain clause inserted. So in this situation, the court can imply terms in the contract in order to give effect to the intention of parties to the contract. Like in this case of Yong Ong Kai and Enting. In this case, this is the case when the defendant entered into a written agreement with the plaintiff. So the defendant signed an agreement with the plaintiff for sale of timber on land. Okay, so the defendant entered into a written agreement with the plaintiff to sell land. Wait, Enting is the defendant, so Enting is the one. To sell timber, to sell kayu balak. So the timber is situated on a land which is a tribe has communal customary right. So I mean the kayu balak, the timber, is actually on a customary land. So it is on a land belonging to certain aborigines, certain customary land. So what is it in Malay? It belongs to certain suku kaum. So it belongs to certain group lah. So what happened is in order to cut timber which is on a customary land, you must get license from the forest department. Customary land is protected under the law. Tanah yang dimiliki oleh orang asli is protected law. On that land, you need to have a license from the. So in the agreement, they did not say anything about the necessity of obtaining a license. Maybe because they overlook it, so they don't put it inside their contract. But it is a requirement that if you want to cut a timber from a customary land, you have to get a license from the forest department. So in this case, the defendant applied for the license, but the license was refused. So in this case, the court held that there was an implied term that the sale of the timber was to be subject to the obtaining of the necessary license. So even though in the contract it does not state anything about if you want to cut the timber, our contract will only be valid if you get the license. Even though it was not stated inside the contract, the court held that it can be implied that if you want to execute the contract, they must have the necessary license first. So in this case, as the license was refused, the contract becomes impossible to perform. So the contract is discharged by frustration because the contract cannot be performed. You don't get the license, you cannot cut the timber. So the court state that as the contract is discharged by frustration, the contract cannot be performed because they don't get the license. The plaintiff was entitled to the returns of the monies advanced to him to the defendant under terms of the agreement. So in this case, even though they did not say anything about necessity of obtaining a license, as it is an implied term, so the implied term has been breached and the contract is impossible to perform. So what they have to do is they have to return all the benefits they have acquired under the contract. So whatever the plaintiff already got from the defendant, the plaintiff have to return to the defendant. Whatever the defendant has already got from the plaintiff, the defendant has to return to the plaintiff. Okay, so that is express terms and implied terms. You have any question about express term and implied terms?
Yes, madam.
Yeah.
Are the implied terms over here? Are they like the concealed clauses inside a contract? Like dia macam isi tersirat ke?
Yes.
Oh, okay.
So when we talk about implied term, we are talking about something which is not in the contract, but it is something that implied that it is inside the contract. So macam yang for this first one, if it is a custom, maksudnya benda tu memang budaya. So it is a standard practice. Everyone inside the industry knows that certain things is done in certain ways. Even though it is not in the contract, it can be implied by customs. So for the second one, even though it is not stated in the contract, if the contract is subject to certain laws, you have to follow the law because the law can be implied into the contract. Similarly, if the contract does not state, maybe some things were overlooked by parties when they are entering the contract, but if it is the intention of the parties, the court can imply the term into the contract. But for the third one, the court have to see what are the intention of the parties, why they did not put it in the contract. So if it is the intention of the parties, the court can still imply the terms into the contract, even if the terms is not in the contract. So yeah, in Malay, implied term is what we call isi tersirat, something which is not in the contract, but it is implied into the contract. Okay.
Thank you, madam.
Any other question on express terms and implied terms? I know the second part may be a bit confusing, but we'll cover all the slides first, and then during our tutorial, maybe we will discuss. Maybe I will give some questions on problematic questions so that you can better understand what are conditions, what are warranties, what are express terms, what are implied terms. Okay. So if there is no question, we continue with exemption clause. So exemption clause is also what we call exclusion clause. So exclusion clause, exemption clause is something which is very familiar. I think you all are very familiar with the exemption clause. It is basically when you, for example, when you are entering into a car park, when you you push the button and then the ticket came out. Inside the ticket, there will be this very small letters stating that the company will not be liable for any damage, theft or injury suffered by the car owner when they are parking at this car park. Or they will say that they will state something like you are parking at your own risk. That is something very familiar, right? If you see at the ticket car park ticket tu selalu akan ada tulis benda tu. You are parking at your own risk. Parking at your own risk. The company will not be liable for any damage or injury suffered by the car owner. Okay, so that is what we call exemption clause. That is an exemption clause. Exemption clause, or it is also sometimes called exclusion clause. So an exemption clause is a term of a contract that attempts either to modify principal obligations or to limit or exclude liability of parties. So when we have exemption clause, usually the purpose of exemption clause is to reduce liability of parties. So like in the normal situation, if someone is parking at your car park, you are responsible to make sure that their car are safe. So in order to limit their liability or in order to exclude their liability, that is why companies who operate car parks usually will put this exemption clause, because they want to limit their liabilities. They don't want to be responsible if anything happened to your car. So that is why people put an exemption clause. So if you have an exemption clause in the contract, the person wishing to rely on, if you have an exemption clause in a contract and something happened, for example, if you are a car park operator and you have already put on your ticket that you are parking at your own risk, if something happened to the car and the car owner take action against the car park operator. So the car park operator, who is the person wishing to rely on the exclusion clause, they must show that the exclusion clause is part of the contract. Okay, so if you want to put an exclusion clause as part of a contract, it must be put by signature. If it is signed, it is easier, or by notice. And it must be notified before they enter into a contract. So that's why for car park, if you realize, before you push the button, there will be what we call a sign which will state all the terms and conditions of parking at the car park. They will state everything on the at the gate. So you are required to read the terms and conditions first before you can push the button. Because once you push the buttons, the car park operator can say that they assume that you have read all the terms and conditions stated at the gate. So it will be so in that case, they can say that the exclusion clause has been incorporated in the contract by notice, because they have already put a very big notice there, even though usually the font will be very small. So when they have put it before the place where you can take your ticket, it is presumed that you have read the terms and conditions. So once you have read the terms and condition, the terms and condition is applicable to you. So you have to follow it. So they can rely on that on that term if anything happens. So this was of exemption clause. Okay, so if the clause is ambiguous, if the clause is not clear, if the clause is very vague, so it will be interpreted to the disadvantage of the party who will benefit, because exemption clause is a very powerful clause, because an exemption clause will deny some people from getting remedies, and because the exemption clause will allow some people to limit their liability, will allow some people to say that I don't want to perform my liability under the law. So that's why the clause must be clear. If the clause is ambiguous, if it is vague, it will be interpreted to the disadvantage of the party who will benefit from the clause, because the court does not want the other party to unfairly benefit from an exemption clause. So if in the case of negligence, if there is an issue of negligence, it is also clear that the exemption clause must have clear and unambiguous words. If the clause is not clear, if the clause is not is vague, the court can still put liability on the person who rely on the exemption clause. But if it is a case of serious or fundamental breach, if it is something very serious, something very bad, usually the exemption clause will still not cover the party who made the clause. And it also does not give any benefit to third party or make any party liable. So for example, in this case, in this case of Malaysia National Insurance Sdn Berhad lawan Abdul Aziz bin Muhammad Daud. In this case, what happened is actually the exclusion clause is ambiguous. So in this case, the exclusion clause state that the appellant insurance company will not be liable if the car was driven by any other person other than an authorized driver. So the exclusion clause state clearly that if you want the insurance company to be liable, the car must be driven by an authorized driver. So if the car is driven by a person who is not an authorized driver, the insurance company will not be liable to pay. So in this case, the respondent is an authorized driver, but there is one small problem, which is at the time of the accident, the respondent's driving license has expired. So he is an authorized driver. So he is not included in the exclusion clause, but there is only one small problem that when the accident happened, his driving license has expired. But in this case, the court still held that the exclusion clause is still cannot be applicable to the respondent because the respondent is still an authorized driver. Even though at that time, if the driving license has expired or anything, it doesn't have anything to do with the fact that he is still an authorized driver. So in this situation, the court state that the exclusion clause still cannot be invoked. So the insurance company still has to pay for the accident. Even though, because the court state that the authorization is not disqualified by reason of the expiry of driving license. So it doesn't have anything to do with whether you have a driving license or not, as long as you are an authorized driver. So that is for exemption clause. Exemption clause is actually, when we learn it during our law of contract, actually exemption clause is quite a long subtopic. But for the purpose of business law, you just need to understand that there are these terms called exclusion clause, and exclusion clause can be used to limit liabilities, but there are certain conditions that you have to follow in order to invoke the exclusion clause. If you does not follow the requirement, you cannot invoke the exclusion clause, so you still have to pay for whatever you are required to pay under the law. So you cannot limit your liability if you does not fulfill all the required elements for exemption clause. So that is an exemption clause. Any question regarding exemption clause? No question? Okay. So if there is no question, we'll go to the last part of the topic today, which is quite a long part, which is factors vitiating a contract. So for this part, what is important is, like I said, one of the main requirement under the law, which is under Section 10 of the Contracts Act 1950, it states that all agreements are contract if they are made by the free consent of parties. So for this subtopic, it concerns about what are the situations where we can say that the party does not have free consent. So what are the situations when we can say that the party who entered into a contract does not consent to the contract? So there are 5 situations where when agreement is said not to be made by free consent. So the first one is coercion. So if the contract was made under a threat, if the contract is made under ugutan, so it is a contract which is not freely given, so it falls under coercion. Or the second one, if the contract is entered because of undue influence, because someone have influenced you to sign the contract, so the contract is also presumed to be not signed, not entered into with free consent. Or the third one, if you sign a contract because someone has lied to you, someone has concealed facts, they did not tell the truth, or someone has lied to you, has give false information to you, which caused you to enter into a contract. So the contract is not given under free consent and you fall under the category of fraud. Or if you are misrepresent, the other party has tell you something which is not true, a false statement. But the difference between fraud and misrepresentation is if it falls under fraud, you try to lie to someone. But misrepresentation is when you say a lie, but actually you also don't know that it is a lie. So you actually believe that it is the truth, but actually it is not a truth. So it is under that is under misrepresentation. And the other one is mistake. So if there is any mistake about the contract can also is also stated to be not signed with free consent. So what happen if a contract is not made by what will happen if a contract are not made by free consent? If it falls under the situation of coercion or undue influence of fraud or misrepresentation, the contract is voidable. So what does it mean by voidable? Voidable means that the contract can be set aside, but the contract can still be enforceable. So if the victim, the person who does not give the free consent, wants to cancel the contract, they can cancel the contract. But if the party who enter the contract without free consent wants to continue to enforce the contract, they can still continue to enforce the contract. So that is what it means by the contract is voidable. On the other hand, if a contract is made by mistake, there is some mistakes regarding the contract. What type of mistake does it mean? We will see later. The contract is void. So if a contract is entered into by mistake, the contract is void, batal. The contract cannot be enforced at all. So that is the difference between voidable and void. So voidable in Malay is what we call contract boleh batal. But a void contract is what we call contract yang terbatal. Okay. So there are 5 situations where a contract can be voidable. So we will see each of the 5 situation one by one. All these are stated in the Contracts Act 1950. So you can refer to the Contract Act. I also put the sections of the I already put the sections of each of the situations inside your slide, so you can refer to each section if you want to see more illustrations or examples which are provided in the Contract Act. Okay, so for this first one is coercion. So what is coercion? Coercion is paksaan. So coercion is when someone commit or threaten to commit any act forbidden by the penal code, or if someone unlawfully detained, if someone threaten that they will injure you if you do not sign the contract, or if someone threaten you that they will kill you if you do not sign the contract, or if someone said that they will detain your property, they will rampas your property if you do not sign the contract, it can be said that the contract is entered due to coercion. So coercion is the act of committing or threatening to commit any act forbidden by the penal code, or when someone unlawfully detain your property, and someone detain of your property, or someone threatened to detain your property. Someone said that if you did not sign this contract, I will steal your car, something like that. So because you are worried that you will be hurt, or you are worried you will be killed, or if because you are worried your property will be taken away, you sign the contract. So that is what we said, a contract is entered into by coercion. So the example of case is the case of Kesarmal against Valiappa Chettiar. In this case, a transfer of land was executed during Japanese occupation, waktu penjajahan Jepun. So at that time, the transfer was executed under the order of Sultan, but it was obtained through coercion because at that time there is a Japanese officer present when the transfer was executed. So at that time, so the court held that the presence of the Japanese officer can be a reason of coercion, because the Japanese officer has the ability to injure or kill someone if they don't sign the contract. So that is for coercion. So coercion is simple enough. Coercion is when you enter a contract under paksaan. The second one is undue influence. So undue influence is when a contract is induced by the relations subsisting between the parties. And then one of the parties is in a position to dominate the other, and that person has used that position to obtain an unfair advantage over the other. So to use the second type of what we call it, the second category of voidable contract, you must have a relationship between the parties. What type of relationship are we talking about? We are talking about relationship, for example, relationship between parents and child, or relationship between a religious leader and their follower, or relationship between a boss and the employee, or relationship between a solicitor and a client. So to use undue influence, to say that you had entered the contract under undue influence, first there must be a relationship between the parties. So the relationship, there must be a relationship between the parties, and this relationship must allow one of the party to be in a position to dominate the will of the other. So one of the party must be more powerful than the other party. And the more powerful party ni has used this position to obtain an unfair advantage over the other, to get something which is too big, something which is too beneficial to him from the other. So that is when we said that a contract is entered into under undue influence. Okay, so elements of undue influence is, first, there must be a relationship. So the second one, there must one of the party must be in a position to dominate. So they must have at least a real or apparent authority. Or second, they must have a fiduciary relationship. Or the other party is mentally incapacitated. So when one party is more powerful than the other, and the more powerful party gets something from the less powerful, from the weaker party, from the less powerful party, there will be a presumption that this contract is entered under undue influence. Okay, so these are the example. The first one is the case of Rosli Darus lawan Mansur Haji Saad. In this case, the court state that there is undue influence because one of the defendants is the guardian of the plaintiff when he was young and orphan. Or like in the case of Alcott and Skinner, in this case, this one lady, she joined a religious sisterhood. So she joined a religious some kind of organization, and when she was in the organization, she agreed to transfer all her assets to the organization. So once she want to left the organization, she is asking the organization to return her assets to her. So the organization refused to do so. So in this case, the claimant bring the action to the court. She claimed that she was under undue influence when she transferred all her assets to the sisterhood. Okay, so in this case, the court held that there is undue influence. Why? Because the transaction was unusually large. Because the claimant was transferring all her assets. In normal situation, people will not transfer all your assets to another organization. Because if you transfer all your assets, how you are going to live? So that's why in this situation, the court held that there is an undue influence. So the court stated that the religious leader, the religious organization, has unduly influenced the claimant, which caused the claimant to transfer all her assets to the sisterhood. Okay, so similarly, if the other party is mentally incapacitated, if the other party is someone who is who is mentally disabled. For example, if the other party is someone who is very old, or someone who is suffering from Alzheimer, or if the other party is someone who is very sick, so or the other party is someone who is in a danger, for example. So like in this case of Encik Nuria lawan Syekh Ali, in this case there is this old Malay woman, Encik Nuria. She was illiterate. So she was someone who cannot write, who cannot read. And she executed a gift of landed property. She gave her whole property in favor of her nephew. So her nephew is the defendant. And then this old lady, she relied entirely on her nephew for everything because she is illiterate. She does not understand, she cannot read. And she is also very weak. She cannot leave the house without assistance. So she is relying entirely on her nephew. So in this case, when she had signed a transfer of her whole property in favor of her nephew, the court held that in this situation, there is a presumption of undue influence. Why? Because Encik Nuria is someone who is relying heavily on the nephew. So when she is relying heavily on the nephew is in a position to dominate. So when the nephew is in the position to dominate, the nephew also get an unfair advantage because she was giving away all her property to her nephew. So that's why the court said that the contract was signed under undue influence. So what we can say about the second one, the second type of voidable contract, which is undue influence, is if the parties are in some kind of relationship. It can be a real relationship, it can be a fiduciary relationship, and the relationship is the type of relationship where one person is in the position to dominate the other. Okay, so the relationship is when is the type of relationship where one party is more powerful than the other. So when there is one party who is more powerful than the other, if the more powerful party gets something from the weaker party, we can presume that there is an undue influence. Okay, so especially when the weaker party gives everything he have to the more powerful party. In that situation, we can presume that there is an undue influence because the more powerful party has received an unfair advantage. He get too much from the weaker party. So how? Because when there is this kind of imbalance in power, there is presumption of undue influence. So how, if you are the more powerful party in the relationship, how to prove to the court that there is no undue influence? Okay, so to prove to the court that there is no undue influence, so if you want to tell the court that yes, we are in a relationship, yes, I am more powerful than the other person because I am his father and he is my son, but there is no undue influence in this case. How to rebut the presumption of undue influence? How to tell the court that yes, we are in a relationship of we have a relationship and I am in a position to dominate the will of my son, but there is no undue influence in our contract. So how to rebut the presumption of undue influence? The person who is in the position to dominate. So in this situation, the father must prove to the court that the son was acting independently of any influence from the donee. So he must tell the court that yes, we are in a relationship and yes, I am in a position to dominate the will of the other party, but I have not done so. Whatever my son has given to me, he is acting independently from any influence. I did not influence him to do anything. So how to prove that you have not influenced anything? You have not caused any undue influence to the other party. You must prove that the donee understand what he's doing. So you must prove that the donee knows what he is signing, and he what you call it, dengan suci hati, he is willing to give the property to me. I did not say anything. I did not influence him in anything. So how to prove that? One of the way is to prove that the other person has been given a legal advice. So in the situation, for example, if you join a organization, for example, you join an organization and you want to give your property to the organization in order to prove to the court that the organization that has not put any undue influence on you, you need to engage a lawyer. So you need to engage a lawyer, and you must ensure that the lawyer has give full legal advice to you, and you are acting on the advice of the lawyer, not because of any influence given on any influence exercised by the other party. So that is how to rebut the presumption of undue influence. So if you did not succeed in rebutting the presumption of undue influence, the contract can become a voidable contract. So if the contract is a voidable contract, the other party, which is the weaker party, they can choose to end the contract, to set aside the contract. Okay, so that is for undue influence. Okay, so undue influence. The first one is coercion, second is undue influence. Third one is fraud. Fraud is penipuan. So there are 5 acts that will constitute fraud. So to say that someone is committing fraud, seseorang telah menipu, first you must prove that someone is suggesting a fact that is not true. Someone is telling lies. Okay, so when someone is telling lies, it is a fraud. Second one, if someone actively conceal a fact. So if someone knows that something is wrong, someone knows something is problematic, but he actively conceal the fact. He does not want to tell the problem. He does not want to tell that there is a problem with something to you. So when someone actively conceal fact, it is also fraud. Or if someone made a promise without intention to perform it. If someone made a promise without wanting to perform the promise, that is also a fraud. Or if someone make any act of omission that the law declares to be fraudulent, is also a fraud. When we want to end a contract due to fraud, you must prove that the other party has the intention to lie to you. So there must be an intention to deceive. So the party who is committing fraud, the other party who is lying, he must lie knowingly. He must have knowledge of the truth, and he must commit fraud without believing in the truth, or he must be acting recklessly. He doesn't care whether it is true or false. He just want to lie because he just want to get something. Okay, so to use the to cause a contract to be voidable by fraud, what you have to do is you must actively commit fraud. For example, the other party must actively commit fraud. So the other party must lie to you. Because if the other party does not lie to you, the other party only is silent. I mean, for example, you want to buy a house. And then when you are buying the house, there is actually some kind of problem with the house. The house have the problem of whenever it rains, the house, the roof will leak. So whenever it was raining, the roof will leak and the house will be covered in water. The house will be flooded each time it rains. Each time there is a heavy rain, the house will be flooded. Okay, so in this situation, if the other party does not tell you that the house is flooded each time heavy rain, each time there is a heavy rains, the silence does not constitute fraud. Okay, because it is your duty as a person who wants to buy the house. You have a duty to exercise ordinary diligence. You have to check the house by yourself. If you did not check the house by yourself, even if there is something wrong with the house and the other party does not tell you that there is something wrong with the house, it does not constitute fraud. It doesn't become a fraud unless the relationship between the parties make it a duty to disclose all facts. So if you have a relationship, for example, a relationship of trust between you and the other party, and the other party have a duty to inform you on everything. If the other party does not tell you all the facts, it will become a fraud. But if there is no such relationship between you and the other party, silence does not equivalent to a fraud. Okay, so if you look at the book, where is my book? Okay, so if you look at the Contract Act at section Okay, so if you look at section 17, so fraud is under section 17. So if you look at section 17 of the Contracts Act 1950, and you look at the illustration. So if you look at the illustration, there is a illustration B. So sorry, illustration A. Illustration A states that A sells by auction to B a horse which A knows to be unsound. So A sells a horse to B, but A knows that the horse is unsound. So there is some problem with the horse, but A says nothing about the horse unsoundness. This is not fraud because, as I said, silence is not fraud. But if B is A's daughter, so B is A's daughter, and B has just come of age. So B used to be a minor and he has just turned 18. So the relationship in this situation, there is a relationship between the parties that make it a duty for the father to tell the daughter that the horse has some problem. So in that situation, if the father lie to the daughter, if the father does not tell the daughter about the problem with the horse, it will become a fraud. But in normal situation, if there is no relationship which makes it a duty to disclose all facts, even if they did not, if they keep silent, they did not inform of the problem, it is not fraud. Or in situation C, B says to A, if you do not deny it, I shall assume that the horse is sound. So in this situation, if someone asks you, does the house has any problem during rain? Does this house has any issue with the roof? If you keep silent, and the other party said that if you did not say anything, I assume that there is no problem with the house. If you keep silent at that time, it will become a fraud because the other person has already asked, and you choose not to tell, so it will become a fraud. Okay, so that is fraud. So fraud is basically tipu lah. So when you are lying to someone, and someone entered into a contract based on your lie, based on the fraud that you had committed, the contract can be voidable due to fraud under section 17. So if the other party knows the truth, but they still keep lying to you, it will become a fraud. But if the other parties lie to you, tell you a false statement, but he does not know that the statement is false, it is not a fraud. It is a misrepresentation. Okay, so a misrepresentation refers to certain false statement made by a presenter without the intention which induce the other party to enter into a contract. So if it is a fraud, it is when you know something is not true and you actively lie to the other person. So that will fall under fraud. But if you tell a false statement to another person, but you don't know the statement is false, it will become a misrepresentation. Okay, so misrepresentation will make a contract voidable if there is a reliance on the false statement. If your false statement cause the other party to sign the contract, if the other party believe your misrepresentation and the other party enter into a contract due to your misrepresentation, the contract is voidable. But there is no misrepresentation if there is no reliance on the false statement. So if the other party does not rely on your statement, if the other party does not rely on your false statement, if your party does not lie on your false statement, it will not become a misrepresentation. And then similar to fraud, silence does not amount to misrepresentation unless there is a duty to speak. So what is the difference between fraud and misrepresentation? Fraud is when the person making the presentation does not believe in its truth. So if the person who says something knows that the thing that he's saying is a lie, it is a fraud. But if the person making the representation believe the presentation to be true, it is a misrepresentation. So for misrepresentation, to cause the contract to be voidable under misrepresentation, the statement must be false. Then the statement and the statement must be a fact, not opinion. Okay, so if the person is saying his opinion on something and the other party sign the contract based on the opinion, there is no misrepresentation. Because an opinion is not a misrepresentation. An opinion is what you believe. What you believe may be true, maybe not. And the statement must be addressed to the plaintiff. And the last element is the statement must induce the plaintiff to enter into a contract. So if you say something to someone else, something which is not true, and that whatever you tell the other person cause them to enter into a contract, then the contract will be voidable under misrepresentation. But if you tell a lie to another person, you mispresent something on the other person, but they don't but it does not induce the other party to enter into a contract. So they enter into a contract not because what you said, but because of something else. There is also still no misrepresentation. So you can see the illustration of misrepresentation under section 18. For example, on section, so you can see at section 18. Under section 19, there are also some illustrations on the type of situation when a contract can be voidable. Okay, so basically the last element is what you say must be the reason why they enter into a contract. So if what you say does not induce the other party to enter into a contract, there is no misrepresentation. So last one is mistake. So mistake is under section 21 of the Contract Act. So if there is a mistake of fact essential to an agreement, the agreement is void. For example, if A agrees to buy from B a certain horse, the horse was dead at the time of the bargain, but both parties was not aware of the fact, the contract is void. So similarly, if you want to enter into a contract with someone else, for example, you want to sell your car, you want to sell your car lah senang. For example, you want to sell your car to your friend, but you don't know that actually the car is already broken. So for example, the car is not used by you, the car is used by someone else. You want to sell the car to your friend, but you don't know and your friend does not know that the car that you want to sell to your friend is actually broken. The person who used your car has already broken your car. So the car is cannot be used anymore. But you still enter into a contract to sell your car to your friend. So in this situation, it can be said that there is a mistake because the subject matter does not exist. The subject matter cannot be sold. So in this situation, the contract is void. So if your friend has already paid money to you, you have to return the money to your friend. Or if you have given the car to your friend, you have to take back. Your friend have to return the car to you. So that is when a contract is made by a mistake. So if there is a mistake of fact, usually when we talk about mistake of fact, we are talking about the mistake on the subject matter. So maybe the subject matter is no longer available, or the subject matter cannot be sold anymore, or the subject matter is not ready at that time. So if there is that kind of mistake, the contract is void. But if there is a mistake of law, if both parties are mistaken on the law, the contract is not voidable, because ignorance on the law is not an excuse. So both parties are presumed to know the law. So even if they are mistaken on the law, the contract is not voidable. They still have to perform their contract. But if the mistake is made by only one of the parties is mistaken about the contract, the other party is not mistaken about the contract is still valid. And then another point is if the mistake is on the quality of the subject matter. So there is a car. The car is usable, but the car is very old. The car is very problematic. That one, it does not invalidate the contract. Okay, so that is sorry. So last one, what are the effects of a voidable contract? So if a contract is caused by coercion, fraud, undue influence, or misrepresentation, if someone enter a contract due to coercion, due to fraud, due to undue influence, or due to misrepresentation, the contract is voidable at the option of the party who did not give the free consent. So it is at the option of the victim. So the person who is coerced, yang dipaksa sign contract, or the person who is lied to, or the person who is misrepresented to, or the person who is under influence, so the weaker party. So it is voidable at the option of that party. So what can they do? They can insist that the contract is performed. So like for example, if the contract is caused by fraud or misrepresentation, they can insist that the contract shall be performed. And whatever lie that they have tell, they have to rectify the lie. Or if they choose to rescind the contract, to end the contract, they does not need to perform the contract. But both parties, if they have received any benefit under the contract, they have to return it. So whatever parties have received from each other, they have to return, because the contract is voidable. Okay, so that is the 5 instances where a contract is voidable. Is there any question? No.
None, madam. Thank
Okay,
you.
so if there is no question, we will end our morning class. We will end our morning class, and we will revisit this topic. We will do a recap on this topic during our tutorial session this evening. And I will also upload some questions for you to answer so that we can discuss on topic 4 and topic 5. Okay, so if there is no question, that's all for this morning. Thank you.
Thank you, madam.
Thank you, Miss.
Thank you, Miss.
Thank you, Miss.
Thank you, madam.